Contention 1, heresy. Any combatants are being tortured by the United States military at its Guantanamo Bay prison camp, United Nations 2006, United Nations Economic and Social Council, Commission on Human Rights. The special report concludes that many detainees have been subjected to ill treatment and to torture, which occurred systematically with the knowledge and complicity of the United States government. Lord Hope of Craighead, member of the United Kingdom's House of Lords, stated that some of the practices authorized for use in Guantanamo Bay by the United States authorities would shock the conscience if they were ever to be authorized for use in our own country. Ex parte Kieran allows Guantanamo Bay to be the United States rights-free zone, Code 2002, Harold John Code, Case Against Military Commissions, Volume 96, Number 2, pages 337 through 344. Military commissions provide ad hoc justice, hence uncertain protections for defendants' rights. The absence of binding legal protection for the accused human rights would become particularly acute should military commissions be convened at the United States Naval Base in Guantanamo Bay, Cuba, where scores of detainees have been transferred. In 1994, the United States Court of Appeals for the 11th Circuit rendered the extraordinarily broad and strongly contested ruling that these alien detainees in Guantanamo are without legal rights and are cognizable in the courts of the United States. Read literally, the panel's holding would permit American officials deliberately to starve the alien detainees, to subject them to forced sterilizations, or to discriminate against them on the basis of their religion or skin color. Bush's claim to the right of sovereign is a gross abuse of power and leads to a state of exception which undermines the Constitution. Agamben, 2005, Giorgio Agamben, State of Exception, page 22. President Bush's decision to refer to himself constantly as Commander-in-Chief of the Army after September 11, 2001 must be considered in the context of his presidential claim to sovereign powers in emergency situations. If, as we've seen, the assumption of this title entails a direct reference to the state of exception, then Bush is attempting to produce a situation in which emergency becomes the rule and the very distinction between peace and war and between foreign civil war becomes impossible. Bush has invoked the state of exception by detaining non-citizens in connection with the war on terror. Agamben, 2005, George Agamben, State of Exception, page 3. The immediately biopolitical significance of the state of exception is the original structure in which the law encompasses living beings by means of its own suspension. Emerges clearly in the military order issued by the President of the United States on November 13, 2001, which authorized the indefinite detention and trial by military commissions not to be confused with military tribunals provided for by the law, or of non-citizens suspected of involvement in terrorist activities. Vacant such as civil liberties becomes a legal civil war, which ultimately leads to fascism. Agamben, 2005. George Agamben, State of Exception, page 22. In this sense, modern totalitarianism can be defined as the establishment by means of the state of exception, a legal civil war that allows for the physical elimination of not only political adversaries, but the entire categories of citizens who for some reason cannot be integrated into the political system. Since then, the voluntary creation of a permanent state of emergency, though perhaps not declared in the technical sense, has become one of the essential practices of contemporary states, including on the so-called democratic ones. The state of exception will ultimately lead to absolutism. Agamben, 2005. Georgia Agamben, State of Exception, page 2. Faced with the unstoppable progression of what has been called a global civil war, the state of exception tends increasingly to appear as the dominant paradigm of government in contemporary politics. This transformation of a provisional exceptional measure into a technique of government threatens radically to alter, in fact, already palpably altered, the structure and meaning of the traditional distinction between constitutional forms. Indeed, from this perspective, the state of exception appears as a threshold to indeterminacy between democracy and absolutism. Advantage 2, cosmopolitanism. Nationalism creates a hierarchy which denies universal human rights. Cosmopolitanism moves towards recognizing and protecting these rights. Appy, 2006. Appy, Kwame A. Cosmopolitanism, Ethics in a World of Strangers, pages 151 and 152. One such escapable obligation is this: when you do something that harms someone else, you must be able to justify it. Those we think is willing to claim that not everyone matters, the Nazis, the racists, the chauvinists of one sort or another, don't stop at saying these people don't matter. They tell you why. Jews are destroying our nation. Black people are inferior. They deserve what we're doing to them. This is what happens when you start to give reasons. Once you start defending your nation or race or tribe, you'll be drawn to explaining why your people's being on top is really better for everybody, even when you're abusing, even those you're abusing. The so-called realists about international relations often say that our foreign policy should pursue only our national interest. Once you start offering reasons for ignoring the interests of others, however, reasoning itself will usually draw you into a kind of universality. If someone really thinks that some group of people generally doesn't matter at all, he will suppose they are outside the circle of those to whom justifications are due. Still, if people really do think someone don't matter at all, there's only one thing to do: try and change their minds. And if you fail, make sure they can't put their ideas in action. I've been saying in the name of cosmopolitanism ideal that we have obligations to strangers. Domestic actions influence international laws and norms. Appy, 2006. Following Appy of Cosmopolitanism, Ethics in a World of Strangers, pages 81 through 82. We should remember this when we think about international human rights treaties. Treaties are law even when they're weaker than national law. When we seek to embody our concerns for strangers in human rights law, and when we urge our government to enforce it, we are seeking to change the world of law in every nation on the planet. We have outlawed slavery, not just domestically, but in international law. And in doing so, we've committed ourselves, at a minimum, to the desirability of its eradication everywhere. Therefore, we propose the following plan. Using the next available test case, the United States Supreme Court will overrule the category of enemy combatant within the decision of ex parte Karen on the basis that under international law and the Geneva Convention, the obligations of the United States to the protection of human rights should take precedent over the analysis of domestic law when the two are in conflict. We reserve the right to clarify intent and will answer any questions during the process. On to solvency. The Karen decision is outdated. Advances in due process jurisprudence are reflected in the courts martial and civilian courts, but are lacking in military commissions. Enemy combatants should be prosecuted under Geneva Conventions. Martinez, Assistant Professor of Law at Stanford and Lead Counsel Padilla, 2004. Jenny Legal Affairs, September 13th, www.legalaffairs.org/web executive exclusive debate club terror 0904. Military commissions have been mothballed for half a century and have emerged from the attic looking rather the worse for war. Where Scali noted in his Hamdi, the Supreme Court's rush to judgment upholding military commissions in Karen was, quote, was not this court's finest hour, unquote. Criminal procedure in civil courts and courts martial has kept up with the changes in the law, while the mothballed military commissions procedures have not. Military commissions are also plentiful and patently unlawful under international law. Individuals who committed war crimes can and should be prosecuted but under the Geneva Conventions. PWs must be tried for war crimes in courts martial, following procedures from the regular procedures for courts martial. Procedures would impose few costs in terms of national security and would offer greater legitimacy in the form of more procedural protections to defendants, including independent civilian review in the U.S. Court of Appeals for the Armed Forces. Although terrorism utilizes unlawful methods for intimidation and protection and the promotion of fear, the response to it should be directed at ensuring the rule of law. Terrorist acts constitute grave violations of human rights. Our response to terrorism, as well as our efforts to thwart it and prevent it, should uphold the human rights that terrorism aims to destroy. Human rights, fundamental freedoms, and the rule of law are essential tools in the effort to combat terrorism, not privileges to be sacrificed at a time of tension. A commitment to uphold respect for human rights and the rule of law will be one of the keys to success in countering terrorism, not an impediment blocking our way. Confirming domestic law under international human rights is the only way to improve human rights protection. Cheney, 2006. Yuval Cheney, How Supreme is the Supreme Law of the Land? Comparative Analysis of the Influence of International Human Rights Treaties upon the Interpretation of Constitutional Text by Domestic Courts, page 1. Brooklyn Journal of International Law, page 1. International human rights treaties require states to bring domestic law in conformity with the human rights norms enunciated by them. In most common law legal systems, this outcome could be largely achieved through the development of canons of common law interpretation by the domestic judiciary, a presumption of conformity applicable to statutory construction. Although these proposals are hardly revolutionary, they could encourage courts to take international human rights law more seriously and to improve the level of human rights protection under domestic law. Our interactions with one another, whether or not we agree, are an end unto themselves. This debate round fosters cosmopolitanism in round. Abbey 2006, Kwame and Appiah, Cosmopolitanism, Ethics, and World Strangers, pages 151 to 152. Conversations across boundaries of identity, whether national, religious, or something else, begin with the sort of imaginative engagement you get when you read a novel or watch a movie or attend a work of art that speaks from someplace other than your own. I'm using the word conversation not only for literal talk, but as a metaphor for the engagement of the experience and the ideas of others. Conversation doesn't have to lead consensus about anything, especially not values. It's enough that it helps people get used to one another. Rights are inviolable. It is the duty of each of us to individually see these rights always expected. Saying 1993. Pierre Summer saying, Secretary General of Amnesty International, Human Rights and Clash of Cultures. New Perspectives Quarterly. No government has shown how distinct values of its culture justify poverty, torture, discrimination, or disappearances. These arguments also do not stand up in the fact that people living in the Middle East and Asia are demanding the right to be respected. What is at stake today is a vision of the world.